Christian teachers, parents and pupils are increasingly facing difficulties as the education system becomes more secular. Pressure groups with their own agendas are approaching schools, offering advice, training and resources. Sometimes schools feel they have no option but to follow all of this advice, particularly when it's backed up by vague appeals to the Equality Act. But what does the Act actually say in relation to schools? This is the first in a series of features unpacking what schools can and can't do in the name of equality and human rights. In this video, we'll see that equality law in England, Scotland and Wales requires schools to protect people, not promote the views of particular lobby groups. It tells schools not to discriminate in how they educate or treat pupils, but it does not dictate what is taught in schools. In fact, the Equality Act 2010 explicitly states that nothing in its chapter on schools applies to anything done in connection with the content of the curriculum. This allows teachers to get on with their jobs properly. Equality law can't be used to litigate over what they teach. The Equality Act does prohibit discrimination, and rightly so. Schools must not discriminate against pupils on the grounds of gender reassignment, religion or belief, sexual orientation, and other characteristics. This includes direct discrimination, when someone is treated less favourably because of their protected characteristic, and indirect discrimination, when someone with a protected characteristic is more negatively affected than others by a general rule that applies to everyone. But indirect discrimination may be justified. For example, if a Christian pupil is told to remove a fish badge from his blazer because it breaches the school's uniform policy, this would be legitimate, because the same rule applies to everyone and the badge is not essential to that pupil's faith. On the other hand, if a school ran a non-uniform day requiring all pupils to dress in the colours of the gay pride flag in exchange for a donation to an LGBT rights charity, some children who object on the basis of their faith might feel they could only attend in uniform. This could damage their relationships with other students and could count as illegitimate indirect discrimination. State schools are also subject to the public sector equality duty. This requires that they have due regard to eliminating conduct prohibited by the Equality Act, advancing equality of opportunity, and fostering good relations between students by tackling prejudice and promoting understanding. However, this is not a charter to promote LGBT rights in schools. Schools should act reasonably and appropriately, taking into account circumstances such as age and cultural and religious backgrounds. So if a school noticed children from different backgrounds were not integrating well, it might encourage initiatives to help them mix with one another. This would be one example of good practice in applying the public sector equality duty. In our next video, we'll see that respecting people does not require agreement. For more information on how equality law affects schools, download a copy of our Equipped for Equality booklet, which explains all of this in greater detail. Look out for more of these videos in the weeks to come.